Hi, this is Carol Hare with Fidelity National and Frank Butler.
I'm Frank Butler, one of the underwriting counsel in the Virginia Beach office.
And we're here today for another title talk. This time we wanted to talk about the Master Intercompany Indemnity Agreement that was entered into in 2015, and it changed the never-ending request for indemnity agreements by and between the various underwriters, such as Fidelity and non-Fidelity owned companies, such as First American, Stewart Title, Old Republic. So, Frank, you, I think, worked with Cynthia in coming up, Cynthia Horney, in coming up with the Master Indemnity checklist.
Oh, no, it was all Cynthia's work.
All Cynthia's work. It was in connection with the seminar materials y'all put on together.
Correct.
Cynthia gets all the credit here. She deserves it. I love checklists because they relieve you from having to find out if you're ready for dementia. They have triggers and reminders so that you don't have to rely on your brain. So the checklist starts out with what companies are parties to it.
Yes, which makes it really convenient because then you don't have to track down the agreement and the amendment to it.
That's right. There've been the original agreement, then it was expanded by adding additional companies. So they're in the checklist, the participating companies?
Yes, it's in section 1.
Okay.
And,
What's not in that list is Southern Title. Unfortunately, Southern Title went belly up and their insureds are without any coverage, basically. So if you've got a policy issued by Southern Title, the question stops there because you're not allowed to go forward because they were not a party to the agreement. All right, so we've got the list of the companies. If you've got an owner's policy or certain lender's policies, is that correct?
yes,
Then you might be able to proceed with completing the checklist requirements and not having to actually get an indemnity agreement because the master indemnity agreement applies. So it's basically a title insurance company's underwriters saying, hey folks, forget the additional paperwork. We've already insured this. We indemnify your company and you're not going to need to actually get an indemnity letter, which we've spent so much time doing. And the lenders, typically it's an owner's policy for the seller in the transaction. And in certain cases, if there's a lender's policy, you can rely on it.
yeah, if the lender acquires the property by foreclosure or by deed in lieu, it remains an insured under the policy. It doesn't become an owner's policy, but it'll take care of liens back in the chain. That's the most significant thing it takes care of is unreleased deeds of trust and judgments back in the chain.
Okay. But the lender who has to be the seller in the transaction, and the lender is the named insured in the lender's policy.
Correct, or it can be their successor.
Or successor assigned, okay. But if I go and buy at a foreclosure and at which the insured lender was the seller through the trustee sale, well, if there was a trustee sale foreclosing on behalf of the lender, and then I bought it, I would not qualify to rely on the master indemnity agreement.
Correct.
Okay.
You should have bought a policy.
Yes, when I buy, I have to buy my own policy when I buy at a foreclosure sale. Or else I'm out of luck.
Correct.
Or else you clean it up as part of the sale from the trustee and the trustee sale to your buyer. Okay, hope that makes sense. All right, what's covered under the indemnity agreement? Liens and unreleased deeds of trust.
That's the most significant things. That
Yeah.
makes things a lot more convenient than they used to be.
Access?
No, doesn't cover
Does
access.
not cover access.
Doesn't cover missing interest if the search reveals that there's somebody who should have signed off on the deed but didn't. That probably needs to be fixed in some manner.
Okay, so the master indemnity agreement is like, we're just here playing the game of we'll indemnify you, you indemnify us, unless it's a significant matter. I mean, not that unreleased liens and deeds of trust aren't significant, but eventually that will expire.
Yes, exactly.
But outstanding ownership interest or access, those are too big of a problem to be dealt with by way of the master indemnity agreement. So as part of your closing, you'll need to actually address those issues. You cannot rely on the master indemnity agreement. Okay.
Right.
Proceed with caution as to certain matters. What you think?
That would be a credit line deed of trust.
Yeah, it does cover the credit line deed of trust, but we got to be careful on that front.
Yes. Typically, what I've seen is, the builder's deed, very large deed of trust does not get released.
Right. And so therefore, we've got to go further, do more investigation. One thing I also would say what's covered as part of your analysis here, when you're looking at the owner's policy or lender's policy, if applicable, you need to look to the parties to make sure that your seller is the named insured. Also, take a look at the exceptions, because the exceptions may include an exception for what is now the matter of concern. So if there's an exception for that unreleased deed of trust in the prior owner's policy or lender's policy, that means you're not going to be able to deal or address this by way of the master indemnity agreement.
Correct, even if there's affirmative coverage for that exception on the policy.
Right. At that point, you'd want them to call you or Cynthia or Paula or underwriting counsel.
Correct.
Okay. So review the owner's policy. You don't need the jacket. You do need schedules A, B, and B2 if applicable. Look at the amount of coverage, because if the owner's policy is for $70,000 and we've got that unreleased deed of trust for $150,000, we're probably going to need more, or at least your very friendly underwriting counsel can advise in that regard.
Yeah, then we can give you an email for your file.
Yeah. So I hope this helps, and the checklist is on the website, on the Fidelity Global website, under underwriting guidelines.
It's in the underwriting center, underwriting guidelines.
Okay, as well as the master indemnity agreement and amendment. All right, thanks for your interest, thanks for listening, and we'll be back.